Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our first case is M.S.H, KB, A.M.H, M.S.H. And we'll hear from the appellant.
May it please the court. Good morning, Mr. Chief Justice. Good morning, Associate Justice of this court. My name is Christopher Watford. I'm an attorney with the law firm of Robinson & Lawing in Winston-Salem, and I represent the appellant in this matter, Ms. Tiara Massey. Before I begin the principal argument before this court, I respectfully request to reserve 10 minutes of time for any rebuttal that might be necessary. If it please the court, it occurred to me that 5 years ago, my client was before a very different court. In fact, 5 years ago to this day, on February 20th of 2019, Ms. Massey appeared in Vance County District Court after having custody of her 3 children removed by the Vance County Department of Social Services. It was on that day, February 20th of 2019, that Judge Keith ordered that my client's mother, the maternal grandmother in this case, shall be investigated as placement for the 3 minor children that are subject of this proceeding. In fact, her grandchildren. But because my client's mother, the maternal grandmother, was a resident of the state of Georgia, any type of inquiry into this placement had to be done consistent with the requirements of the Interstate Compact on the Placement of Children. You'll hear the term quite frequently today. I'll refer to it as the ICPC. A home study had to be conducted and had to be returned to the Vance County District Court before that placement could be considered. Now, Ms. Massey is present 5 years after that occasion here because she agrees with the dissenting judge at the Court of Appeals that based on the unique facts and circumstances of this case, the trial court did commit error when it made an award of permanent guardianship to a paternal great-aunt without first receiving the home study it had ordered 3 times during the case, ordered expedited, and even continued the permanency planning review hearing that gave rise to the order that's now under appeal for the purpose of receiving the completed ICPC home study from Georgia.
Can I get your answer to the hypothetical question that the majority posed in the opinion, which is if there are 10 out-of-state relatives, all potentially suitable for placement, and the court orders home studies, does the court have to order the home study? And if it orders the home study for the 10 relatives, does it need to wait on all 10, even if one comes back and says this would be a perfect placement and it's going to take months to finish the other ones? What's your view on that?
Well, thank you for your question, Justice Deeds. I think that's a fair question to ask. I think as a background, I'll disclose to this court that I represented the Department of Social Services in court for 7 years and dealt with this same very type of process. I think what the dissenting judge relayed in her dissent is the same that we request. We don't want to suggest a categorical rule to impose here because in my own experience, out-of-state home studies, ICPCs, are started, stopped for various kinds of reasons. The most common reason was the fact that the out-of-state placement could no longer care for the minor children because of health circumstances, or something would occur on the criminal record report as the home study began, which would lead the receiving state at that point under the terms of the ICPC to say that we would not approve this based on this designation. So in terms of having to wait for the 10, I certainly believe that the court gave consideration that this was an important asset to have in making a permanent decision about a child's care, that it would follow through. But we don't ask at this point to impose a requirement to wait until each and every one has been completed. I think what makes this distinct and what the dissenting judge and our position emphasized was, at this point, look at the situation itself. The court ordered this 3 times. It's not as if making one order for 10 relatives. We made 4 orders and a continuance order for 1 relative in this particular circumstance. And so
what I understand, though, the majority then, I think the majority agreed with your position and said you certainly could do the 10 home studies, but if one comes back and it's time to make a decision, the court could just say, we've got a home study that says this is the right place and we're going to take it. And I understand the majority in this case to be saying, and that's all we think the trial court was doing here, was the court said, do the home study on 1 relative. But there's another relative that's not out of state. There's no need for a home study and is within the community. And therefore, because I've determined that in the best interests here, remaining in the community is sort of paramount, there's no need to wrap up the home study because nothing will change when that comes in, given the trial court's reasoning that that's the most important factor.
Well,
so what's wrong with that?
Well, Justice East, I think your understanding of the majority is correct. That's how I read the case as well. And I think part of the problem that you have here is that the court made this investigation a priority. The record states that it was ordered to be expedited. This had been pending since February 20th of 2019. A key thing to the fact of the matter is we're talking about a permanent disposition when you award guardianship. It's not something that can be turned on and turned off at this matter. So we are talking about the next 17 years of these children's life determined who their caretaker would be. So as we look at, again, not a categorical approach, but an individual one, this was information the trial court sought and wanted. And I think there's also the equity issue the dissent talks about in that the only way this grandmother could be considered for placement was through the ICPC. And the only way that you can do that is through DSS initiating the process with the state office here in North Carolina, who then communicates with the state counterpart in Georgia, who sends the various local agency out, whether it's regional or a county like we have here, to actually do the home study. And I think another point that the dissent points out that the majority did not give attention to was, well, the assumption is that the result would have been the same. And again, for some of those things that you cite there, community of residence, the 3 years they had already been in that placement. Again, we contend the 3 years they've been in the placement was because the home study was not completed timely or initiated timely. And all those things are part of those factors. But I think, again, when the dissent talks about why we have the ICPC to begin with, is to consider all options and all information. I've never heard a district court judge say, I want less evidence upon which to make a decision. And so those questions that are raised in the dissent that the trial court made findings about 6 kids would then be in the home versus 3, local community residents, they're bonded to the paternal aunt who lives in Vance County. All those are valid concerns, but I think the concerns that raised with placement with the grandmother can be answered there by an investigation by a third party out-of-state agency. They're the ones who can put eyes on grandmother. They can go into the home. They can conduct those criminal and background checks in their state. And so they provide that information. So in the end, what we're saying here is, at this point, before making this permanent decision about guardianship, give the grandmother the chance that you allowed her initially. You don't order a home study 3 times, order it expedited, and then continue a case to receive a home study unless you want to hear that information or that information is valuable to the court's decision. So for that reason, we are asking the court to kind of reach back a little bit in its jurisprudence, not this court's jurisprudence, but in the Court of Appeals, in Re LL, which is cited as part of the brief to discuss the importance of the ICPC. And in that case, it was, unfortunately with all my cases, it's always a unique fact circumstance. But when it came to it, there was a dispute between DSS and a foster home out of Johnston County. And so part of the work through DSS was they sought to secure an ICP home study on an out-of-state relative. And so the ultimate result of In Re LL was to affirm a relative priority for placement, but also to state that since the court received an ICP home study during the course of the hearing, which led to the eventual adverse decision DSS appealed, that trial court should have paused and should have received the results of that ICP home study, again, before making such a final and kind of momentous decision regarding the permanent plan, the permanent placement for the minor child.
So 7B 903 says that the ICPC has to be complied with when a juvenile is placed with a relative outside of state. That didn't happen here, so why should we conclude that the ICPC was applicable?
Thank you. Thank you, Justice Allen, for your question. At this point, I think there's a disconnect between the majority's reading of 903A1 and further provisions within the Juvenile Code contained at 7B 3800. Specifically, what exactly the ICPC applies to, what its goals and aims are, and what it hopes to provide the district court in making these decisions. So while I think it's been characterized as the plain language says if you don't place, then the ICPC's compliance is irrelevant or it's not for consideration, kind of belies the reason we have the ICPC in the first place. The ICPC, as mentioned there in the Juvenile Code 7B 3800, codifies its purposes and its goals. So for example, one of the goals is something I've already spoken about in my previous answer, which is to provide the most comprehensive information before making a placement. Now, if we accept the majority's position, and I agree it's fairly clear and outlined there, that we don't determine whether or not compliance was necessary until an out-of-state relative was actually done, creates this weird kind of feedback loop that we enter into, which is before I determine whether or not to make a placement, shouldn't I actually have the material that I need to determine whether the placement should be made? So how do we determine whether an out-of-state relative is appropriate? Well, we go through the ICPC process. We request a home study. They typically come back in less than 6 months.
Let me go back to my earlier question then. I'm sorry. Suppose you had a circumstance, change the facts of this case slightly, where you've gone into a hearing, there's two potential placements. One, they're both aunts or uncles, one out of state, one in state, that's in the same community where the child is residing. And so and the trial court says expressly at that hearing, I've determined that the single most important paramount factor in the best interest of the child is that this child remain in this community because of all the ties the child has to the community. And therefore, I'm going to place the child with the aunt or uncle that lives in this community. And so because I'm not even going to consider the out-of-state, I don't even need to worry about a home study or anything like that. Would you have any issues with that order?
Well, I believe I would. I think the question here is, and what sets the timing is the decision in your hypothetical based on before the court decides to award or order a home study, as opposed to ordering a home study and then proceeding without one without any explanation.
But I guess the Court of Appeals majority, and this would be my question, I think their reasoning was, if the determination by the trial court is that the single most important factor for best interest is to remain in this community, then it wouldn't make any difference what the home study says because nothing can change that. And if the trial court has committed to that conclusion in the best interest analysis, then it's essentially harmless. Whatever happens in that home study is just not going to matter. So even if there was an order to do it, just wouldn't affect the outcome. So, it's sort of an argument here that doesn't change the result. But I take it you just disagree with that. You think?
Well, I couldn't disagree, and I'm loath to reduce the decision of best interest to a minor child down to one consideration only. I think when we look at this particular circumstance, the dissenting judge was right. You've ordered this. The mother could not have done this or produced this beyond herself. That would have been a violation of law if she tried to do something. So we have this decision. There's multiple factors that go into that. And I think the key thing is what the Court of Appeals wants to see, and truly what this court wants to see, is in making this decision, the trial judge works through the process. So establishing kind of a threshold, or at least an exclusionary type of consideration, is not part of that best interest determination. So I think the home study does have value, and if you refer to the record, the Vance County Department of Social Services finally initiated the case in November of 2021, and the grandmother, had already complied with the fingerprinting, had already done the mandatory drug testing, and was in place for the home visit. So much like LL, things were moving and things were in the process. It could have been held up, it could have been continued for another time to receive those results. Now, I will say at this point, the dissent favors an approach where they would vacate the entire order and then remand for new consideration. In preparation for this, I think my position on that's been evolved, and perhaps what's needed is a reversal and a remand, because it's not lost on me the considerations that you have, Justice Dietz, in that the kids have been with the paternal grandmother, and I've been very careful because it's been my client's desire not to bemoan or try to humiliate the paternal grandmother or cast aspersions about her. But the home study here from ICPC, an honest, straightforward, third-party review, and then the facts and circumstances, including the last 5 years, are something the trial court can consider on the remand. And for the record, the case is already supposed to be remanded because of the error the Court of Appeals unanimously determined with the conditions of electronic visitation. So while these decisions are being made, now's the time to do what was promised back on February 20th of 2019, what was ordered by a court, what was ordered again by a court in February 2021, which was ordered again by a court in July of 2021, and what was the subject of a continuance of this very hearing. So all those things taken together would justify waiting till this home study has been received in order to make this very important decision. So I would disagree with a single consideration test to determine whether or not this home study has value or its omission would constitute harmless error.
I have a slightly different question about the extent to which the trial court's ultimate decision to proceed without the home study was without explanation in this particular case. And it seemed, my understanding of the order, and so please correct me if I'm wrong or what I'm missing, it seemed to be that the trial court was saying, I already know that the grandmother has 3 other children in the home, that one of those children has special needs that will require the grandmother's additional attention. In light of those factors, it seemed like the trial court was saying, maybe initially when we didn't know as much about the grandmother, a home study would give us more information and would be useful. Mm-hmm. But as in your example that sometimes home studies or ICPC studies are abandoned because the relative can no longer take the children, is this a situation where the study was abandoned because the additional information about the grandmother made it clear that that would not be a good placement?
And thank you, Justice Earl, for your question. I don't know exactly how to answer that because the trial court really doesn't give us any definite clues. Mm-hmm. For example, the trial court was confronted with that same type of concern at the time the case was coming to an end in Vance County. And so the advocate for the respondent mother at trial, after going through the hearing, after both paternal grandmother and maternal grandmother testified at that final day of hearing in February of 2022, she asked, well, what about the home study now? Because things can change with guardians. The number one reason why guardianships tend to not work out is because health issues of the guardian or challenges with the needs of the children that are unforeseen at the time guardianship is awarded. So the response to the trial court to that direct question, so are we still going to get or do we still need to have the ICPC home study completed, was nothing on the trial transcript. So the trial court could have given us its reasoning or its understanding. At this point, all we are left with is just what the order says, and the order seems to believe that at this point, the paternal grandmother was good enough, and so that any inquiry should end. But why, or the reasoning behind the reason to shut off the inquiry, we just simply don't have.
So what's our standard of review here?
Well, the standard of review is one that I raise in the brief because the dissenting judge pointed that out. The way that this case was brought to the Court of Appeals was as an error with statutory compliance, that you have to go through the ICPC. And so the normal standard for review for statutory compliance of a trial court is a de novo review to see if the court obeyed the requirements of the statute. And so at this point, we believe that de novo is the correct standard to look at this, as opposed to the abuse of discretion standard, which the majority indicates that it applied to the ultimate decision to award permanent guardianship without waiting to secure the results of the Georgia ICPC home study.
The reason I ask that is because it sounds like, a lot of the points, or many of the points being made in the questions and the arguments seem to be aimed at a best interest determination, but isn't your argument ultimately a statutory one?
Well, it is, it certainly, and thank you again for that inquiry. I think one of the things the majority discusses is that the plain language says you don't have to comply with the ICP if you don't make placement. So after a placement is made or not made, then you go back and review whether or not compliance is necessary. At this point, that compliance, forgive me, I think that the core concern here is away from the best interest determination to be able to fund that statutory compliance to get to the best interest determination. For example, how do we have the most valuable information, or most comprehensive information to make this decision of whether or not to grant placement? And so you can't do that without complying, in this case, without the ICPC home study, because there's no other avenue for the maternal grandmother to have her home and have her situation formally reviewed because she resides outside of the state of North Carolina. And I see I've already went through my time here. Is there any other questions before I sit down and turn it over to the appellees? All right, thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court, to the Chief Justice, Justice Newby, and Associate Justices. I am Tiffany C. Myers, and I represent Vance County Department of Social Services as the appellee in this matter. In hearing some of your questions about this case, I would like to first start with how many times the home study was ordered. In the initial 7-day return on the non-secure, I believe the language in there was not that a home study be ordered, but that the grandmother be investigated. And that did not implicate that a home study would be done, but just that she be investigated as a possible placement. And then there were 2 additional orders that asked for the home study to be initiated. And from my review of the record, it seems that that was done based on the mother in this case requesting that a home study be done, and the grandmother being willing to have one done at that time. And then I believe in the interim, there was a recusal of a judge where she recused herself from the case. And then once the new judge came on, that judge asked for it to be expedited. I think the fallacy in the appellant argument that the home study needed to be done in order for the judge to have the information that she needed to be able to make a placement decision, I think that that is considering that the home study is the only factor that she needed in order to make her decision.
Before you go on, can I just get a bit of clarification about, because I wasn't sure if you were, the dissent alleges that your client, I think the word used was egregious violations of court orders by DSS. So am I hearing you make an explanation that in fact, DSS did not violate any court orders, or at this point are we sort of acknowledging that there was an order to do the home study and for whatever reason it just didn't get done?
So I was not the attorney at the time, so I don't know exactly what happened during that time. What I would say is that there are all kinds of factors that are involved because we're dealing with 2 different states having to, like, which department or which, excuse me, district in the new state needed to be in charge of doing the home study. There are all kinds of implications of why there was a delay. I do believe that the trial court was in the best position to determine whether there was an egregious error in not complying. If there was a non-compliance issue, the trial court was in the position, they have the contempt powers of the court, and they could have done that. I don't see anything on the record that the court even considered that it was something that Vance County was egregiously not following.
Well, so If DSS keeps delaying and delaying and delaying in complying with trial court orders, and the trial court's ultimately tasked with determining the best interest of the child, isn't there an inherent conflict between not complying with the court orders in a timely fashion and then ultimately having the kids settled and a trial court judge less likely to want to disrupt that?
I understand those factors. I believe that at the time when the expedited home study was asked for in, I think it was July of 2021, at that time, there had already been several permanency planning hearings, but there was maybe 2 months between the initial initiate the home study and the expedite the home study. I think those orders were entered within 2 months of one another. So I don't think that it's clear that there was this egregious delay. I think there is an implication in the dissent that somehow Vance County was delaying it on purpose such that the kids would be in placement longer, but I don't see that on the record, and I don't see any indication that the trial judge saw it that way either, because I would think that she would have filed a show cause against the agency if that were the case.
Right, but on the flip side, we don't seem to see a very good explanation of what the delay was, and if they'd expedited the home study, they would have had that information before the third permanency hearing, because that's the timeline. I mean, it's sort of laid out, that they would have had that information. And so I feel like if your client's position is, well, we'll get to it when we get to it, even if there's a trial court order, then I get into a question of, is there actually an abuse of discretion, because these trial court orders are not being complied with, and at some point it's just like, well, what was the point of all of this?
I do understand that. I just believe that there were other factors that maybe weren't on the record or before the court at the time. My understanding is that when the initial investigate the grandmother was in the order for the non-secured, that the grandmother and the mother were not on speaking terms at that time. And it wasn't until sometime in 2020 that the grandmother made herself available to the court so that the court could consider her, or that Vance County DSS could consider her as a placement. At that time, I believe the children had been in their placement with the paternal great aunt for about a year at that point. But Vance County maintained placement authority throughout this time. When the mother came forward and requested that the ICPC home study be done, that wasn't done until much later. But during the pendency of this case, there were several hearings where the grandmother made herself available to the court. The court was in the best position there was a whole hearing over several days that went forth, where any information that the home study would have provided, i.e. the home study is gonna do a background check, they're gonna go into the home and be able to see that it's safe, they would be able to interview the grandmother. The court interviewed the grandmother through the court hearings, over several court hearings at that point, and they were able to get information that the home study would have provided possibly, but even more, they were able to get it directly from the grandmother at that point. And then in addition to that, I think that the way the order is written, they considered maybe the home study in the best light possible. So the drug screening would have come back okay. The home is okay, but they looked at other factors. I believe that the home study is but one factor, and also that the home study is not the deciding factor as to whether these children should have been placed out of state or in state. It is just we're not in that other state, so they have the ability to go to the home and see that it's safe. I think the goal of the ICPC home study is to ensure that the children are not being placed somewhere where it's inadequate or they don't have what they need. And I think that that's only but one factor. And with the court being able to see the grandmother and to question her, the social workers, and everyone else in the case, even the mother, they were in the best position at that point to decide what was the best placement for these children.
But by statute, the ICPC is the deciding factor in the sense that the child can't be placed there without one, right?
That is correct.
And so I do want to make sure you would agree that if that there's a difference here between what the Department of Social Services can do and what the court can do, and if the court orders, even if it's at the mother's request, but if the court orders that the ICPC study be done and then orders that it's expedited, Department of Social Services doesn't then at that point have the discretion to say, well, we just don't think it's necessary or a good idea.
I agree, and I don't think that was the case in this particular situation. I believe that we were dealing with another agency out of state, and we're at their beck and call at that point as to when they are able to get us the information that is needed. I do agree that the statute says that the children cannot be placed there without the ICPC home study being done. However, in this case, I don't see any information that they were actually gonna be placed there. Throughout the pendency of this action, Vance County did have placement authority. In fact, in the first order that the court ordered that the ICPC be initiated, there is language in that order that said that Vance County still, it says Vance County DSS shall determine placement at that point. So I believe that the court was still allowing Vance County to do the investigation as far as whether or not the children should be in state or out of state, and that they still had placement authority at that time. Now, I do agree that the court had the ultimate decision-making as to where the children would be permanently, but they did leave the discretion to Vance County throughout the pendency of the hearings.
But they also ordered Vance County to complete the ICPC with the grandmother.
That's correct, Your Honor. If there are no other questions remaining, I'm going to reserve the rest of the time for the guardian ad litem.
May it please the court, I'm Erica Hicks with Robinson Bradshaw in Charlotte, and I serve as the guardian ad litem on behalf of the children in this case. I would like to begin my remarks by just highlighting what this case is truly about, and that is 3 children who 5 years ago this month were removed from their parents' custody and placed with a great aunt. At that time, the children were 5 months old, 1 year, and 2 years old. They are bonded with their great aunt, they are happy and healthy in her home, and are having all of their needs met. Here today, we must remember that the children's best interest is the, quote, polar star of the juvenile code. And the children's best interests are served by ensuring that they have permanence as swiftly as possible. What this case essentially boils down to is whether the trial court could have made their best interest determination without the ICPC home study of the grandmother. And I believe that answer here is unequivocally yes. You know, the trial court in a permanency plan hearing has the authority to consider any evidence that it believes is relevant, and as a trier of fact is in the best position to weigh that evidence. Here they considered, you know, a lot of different evidence regarding the great aunt, including that was the only home the children have ever known, that removing them from her would remove them from their community and their extended family, and again that they just have a strong bond with the great aunt. On the other side, they are not bonded with the grandmother, and in her home would be 3 of 6 children, one of which has special needs and requires, you know, obviously special attention. And prior to a visit with the grandmother in late 2020, they had not actually seen her in 2 years. So here the court considered all of these factors, and they decided that, you know, regardless of whether or not the ICPC study came back positive, that the children's best interest would be served staying with the great aunt. And just the home study.
How do we know that last point that you just made? How do we know that the court's determination was, it will not matter what the home study says because I've determined it's so important to remain in the community of residence that it's not going to matter what the home study says? Right, is that an inference, or is there something expressed that where we can find that?
So thank you for your question. You know, I don't know that there is a, you know, explicit statement to that effect, but I think looking at their analysis in the order, it makes it pretty clear that, you know, they are reviewing various factors like that I've laid out already, but that, you know, they really focused a lot on the fact that they're in their community, that the great aunt is the, you know, the only parent they've ever known, And again, kind of as Ms. Myers stated, that, they did consider the grandmother as if, everything would have came back perfect with the background check. They considered, the fact that she had the other 3 children. I think they even looked at like her income and various things. So they did consider the grandmother and had, information on her to make that decision. And so I think the fact that they focused on these other things, kind of indicates that that's what they considered to be the most important factor here in determining what was best for the children. So essentially, my point here is just that delaying the proceedings in order to wait for the ICPC home study would have just simply been unnecessary and would create further delay in providing permanence for these children. And remanding the case now on this point would only create further delay in having to wait for a home study that, frankly, would most likely be pointless for the court's analysis. And as the Court of Appeals majority states, this is not necessarily meant to be, kind of a blanket order that, the court never has to wait for an ICPC to rule out an out-of-state relative. And under a different set of facts, that might be an abuse of discretion. But here, when they had all of these facts on record and had the ability to weigh all of this evidence, it just simply was not necessary to wait. Again, I want to stress that the children are in the only home they've ever known, with the only parental figure they've ever known. They are happy and healthy, and they deserve to feel secure knowing that their home is permanent. So if there are no other questions, I respectfully ask that this court uphold the Court of Appeals ruling on this. Thank you.
Thank you, counsel. Rebuttal.
In terms of rebuttal, I think the questions asked were fair. How do we know that this is the best interest? Are we just assuming things based on the record or the indications that were made by the trial court?
Before you get going on that, I wanted to ask you, so it seems to me that you've made a number of policy arguments for why the ICPC should apply to a potential out-of-state placement. The word potential is not in the statute. Do you have a textual argument?
Well, if it pleases the court, I think, and it's cited in the brief there, in terms of the placement shall be in compliance with the ICPC and 903A1, it has to be read together with 7B 3800, which discusses what are the goals and the processes of the ICPC. Now, in the brief, I also bring forth Regulation 7 as it relates to studies of out-of-state relatives as part of the consideration of the ICPC process. I think in terms of the disjoint maybe between here, the majority and the dissent, was viewing the ICPC as something to make sure it was complied with kind of after a placement was made. And the dissent says, no, 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 the ICPC process and compliance is from the entire investigation, consideration, and the eventual return of the ICPC home stay to the district court, and eventually the placement, if deemed in the best interest, or the ICPC language is not contrary to the interest of the child for that out-of-state placement. And so for those reasons, there is that difference in opinion. I guess that's what a dissent is a difference in opinion as it proceeds through there. If you see the ICPC as a placement was made, like a JDMJ case by Cabarrus County, but then no home study was ever ordered, then that definitely is not in compliance with the ICPC. So again, I see it as a dissent sees it, which is reading those two statutes together. It's about the process, not just the ultimate final decision regarding placement.
Thank you.
How do we review the trial court's finding that, or conclusion of law, number 7, it would be contrary to the best interest of each of the juveniles to place any of the juveniles with Ms. Thomas, their maternal grandmother?
Well, I think one of the things that you would be looking for is, based on a review of the record, where is the record as it relates to the ICP's home study for the maternal grandmother? One of the things...
Can we not look at the dozen findings of fact that the trial court made with regard to its analysis of the home of the grandmother?
Thank you, Mr. Chief Justice. I think one of the things to underscore is the fact that the maternal grandmother had to travel to Vance County DSS Court on no less than 2 occasions from her home in Georgia, because no home study was actually ordered to be done on her home. It was ordered, but it was not completed. So on her own recognizance, she demonstrated how much she desired placement by making herself available to the court. The problem here is with the statute, because I think what the court's asking is, could the maternal grandmother's testimony be a substitute for an ICPC home study? What's better than the trial court being able to place eyes on the maternal grandmother and ask questions? Where our law says it's not a substitute, that even if the maternal grandmother presented in February of 2022 and had astounded the trial judge, there is no way under the precedent of the Court of Appeals in Ray VA that that trial court could have placed with the maternal grandmother, because the ICPC process had not been started and there was no word from the ICPC authority in Georgia, again, the required finding and determination that the placement would not be contrary to the interest of the children. So again, even if that were a substitute, the court would be restricted by statute from making that placement. One of the things I do want to share and make sure the court takes aware of is the accurate timeline as we go through. I think it was correct that the order directed that the maternal grandmother should be investigated in February of 2019. It didn't use the words ICPC home study, but I asked the court to explain or to provide some guidance for practitioners in my role, which is how else do you investigate an out-of-state relative? And the North Carolina Department of Health and Human Services manual makes it clear that is the job of the Department of Social Services. It says they shall investigate all in-state and out-of-state relatives prior to making a decision regarding placement of the juvenile. And to me, that seems common sense. Nowadays, perhaps when I grew up, everybody lived in the same community. Maybe didn't go too far over to the next county. People move around nowadays. So it's not uncommon to have individuals who may have relatives who are out of state. So do we write them off as part of the process of caring for the grandchildren? I don't think that's what we believe the majority did, but that's kind of the practical effect here as it relates to maternal grandmother. And again, she showed up in court twice because she wanted to have placement of her own grandchildren. We don't disparage paternal grandmother, but that shows the commitment. And why was she there? Because the only way she could be under review was not being done. So February 20th, 5 years ago today, is when Judge Keith says, investigate the grandmother. February 25th of 2021, grandmother appears, hears from the bench the judge say an ICPC shall be home study should be ordered. Now that order doesn't get filed until May of 2025, or May 25 of 2001, so 3 months later. In July, no home study has been returned, so that's when the court renders its order for an expedited home study. Now, oddly enough, under the actual ICPC, an expedited home study could have been ordered first because of the class of relative that was being considered. The other way to order an expedited home study is when the first home study doesn't come back within 60 days, then you can order an expedited home study. But when we see the order from July the 7th, which said expedite this home study, Vance County DSS, is not filed until January 14th of 2022, during the permanency planning hearing under which the order is subject to review. So even if it were sent, according to the social worker's testimony, November 5th of 2021, which contradicted an earlier statement Vance County DSS made to the court, the indication it should be expedited would not have got there, or the order with the file stamp and the signature, until the permanency planning hearing was already in process.
What's your response to the department's argument that if there was any problem with the department's compliance with the trial court's orders, that it was up to the trial court to enforce its own orders and to make that determination?
Well, I've also looked in that, and so, the available avenues a trial court has, and I think the argument was it should have issued a show cause. Well, perhaps that was available, but for the trial court, it was enforcing its orders. I don't think a trial court can assume that DSS is not going to follow its orders. Because what's the outcome of a contempt citation? A finding by a court that Vance County DSS willfully and without legal excuse disobeyed an order of the district court? Is that really what the result should be? And what I would argue is that the court was enforcing its orders. I mean, as late as August of 2021, again, the expedited still hadn't been entered, so it couldn't have been sent by then, but the regular order for home study was. it ordered the case be continued. And again, as a clue into the position of the trial court, to receive the home study. So it was under the impression, as of August of 2021, and based on the representations made by Vance DSS in October of 2021, that the home study was on its way. So even if a show cause order could have been put in place, again, what was the basis or the good faith basis that the district court could have taken that action? As I see my final time on rebuttal is running out, at this point I would ask if any of the justices or the Chief Justice would have any further questions. If not, I thank the court for its time.
Thank you, counsel. Thank you, everyone. Mr. Clerk.